For centuries, the imposing Gothic spires of London's royal courts of justice have stood as a monument to the ultimate unyielding power of the law, a place where grand reputations are either meticulously chiseled into history or shattered into 1,000 irreparable pieces on the cold stone floors. Within these echoing high-ceilinged corridors, the air is constantly thick with tension, a quiet battleground where the wealthy, the famous, and the powerful bring their deepest grievances, hoping that the scales of justice will tip in their favor. It is a world governed by strict, unforgiving rules of evidence, where passion and public sympathy mean absolutely nothing if they cannot be backed up by cold, hard facts. Yet, every so often, a legal clash comes along that transcends the ordinary boundaries of civil litigation, transforming from a mere dispute over rights into a sweeping, high-stakes drama of Shakespearean proportions. This is a story about what happens when the absolute peak of social privilege, fueled by deep-seated personal animosity and unmatched egos, collides head-on with the ruthless, calculating machinery of the British court system, leading to an ending so catastrophic that it will be talked about in legal circles for generations to come. To truly understand the gravity of the storm that has just broken over London, one must look past the glamorous headlines and peer into the shadows where this massive conflict was first engineered. For years, a quiet but incredibly intense war has been brewing between some of the most recognizable faces on the planet and the towering, fiercely defensive giants of the British press, a conflict that was always destined to find its ultimate resolution in a courtroom. The claimants in this historic saga believed they had found the perfect opportunity to strike a definitive, crushing blow against their long-time media adversaries, assembling a star-studded coalition of public figures who were united by a shared sense of outrage and a desire for historic vindication. They approached this battle not merely as a search for financial damages, but as a righteous crusade, confident that their status, their narratives, and their collective influence would carry them to an easy victory. But in the unforgiving arena of the High Court, narrative is a dangerous substitute for proof, and the deeper they marched into this legal minefield, the more they exposed themselves to a counterattack of unprecedented ferocity. As we prepare to unravel the shocking details of how this multi-million-pound crusade completely fell apart, we invite you to become a permanent part of our community by subscribing to this channel and hitting the notification bell, ensuring you do not miss a single second of this unfolding, multi-part investigative series. The early days of this litigation were characterized by an atmosphere of absolute supreme confidence, with the legal teams representing the celebrity coalition projecting an aura of invincibility that captured the imagination of the global public. On paper, their grievances were spectacular, painting a dark and deeply unsettling picture of systematic privacy violations, high-tech surveillance, and underhanded tactics that they claimed had ruined lives and compromised the sanctity of their private worlds. The public watched in fascination as this extraordinary alliance, which brought together royalty, legendary musicians, and cultural icons, prepared to hold the powerful publishers of Fleet Street accountable under the brightest spotlight imaginable. In the background, powerful campaign groups and strategic advisors whispered promises of a total systemic revolution, suggesting that this single trial would finally break the power of the tabloid press once and for all and usher in a new era of strict media regulation. There was a palpable sense of historical inevitability in the air, a belief that the sheer momentum of these famous names, combined with the dramatic rhetoric of their high-profile lawyers, would be more than enough to force their opponents into a humiliating, costly surrender before the first witness even took the stand. However, beneath this polished, highly choreographed surface, the structural foundations of the entire case were already beginning to quietly but rapidly decay. setting off subtle warning signs that only the most experienced legal minds could detect. A courtroom is not a television studio or a public relations arena. It is a place of brutal clinical scrutiny where every single assertion must be anchored to verifiable, unimpeachable documentation. As the defense began its meticulous, slow-burning preparation, they did not focus on the emotional weight of the claimants' public statements, but rather on the glaring, increasingly problematic gaps in their actual physical evidence. The seasoned observers watching from the sidelines began to notice a dangerous trend, as the celebrity legal team seemed to rely heavier and heavier on broad assumptions, historical suspicion, and dramatic inference rather than the concrete, ironclad proof required by a high court judge. The stage was quietly being set for a classic legal ambush, a moment where the grand illusions of the powerful would be forced to confront the cold, unyielding reality of the law, and as the clock ticked down to the start of the trial, the tension in the legal world reached an absolute fever pitch. When the highly anticipated trial finally commenced, the sheer magnitude of the legal disaster began to unfold with terrifying speed, leaving observers in the gallery and seasoned legal experts completely breathless. The defense, representing the publisher of the Daily Mail and the Mail on Sunday, did not merely mount a passive resistance. They launched a devastating, highly coordinated offensive that targeted the very heart of the claimants' allegations. Almost immediately, the cracks in the building blocks of the case became impossible to ignore as the presiding judge began to systematically dissect the evidence presented by the celebrity legal team. It quickly became clear that the sweeping claims of systematic phone hacking, illegal wiretapping, and illicit information gathering were built not on hard, verifiable forensic data, but on a fragile web of historical suspicion and speculative leaps. With each passing day, the high-profile lawyers representing Prince Harry and his co-claimants found themselves forced onto the defensive, struggling to justify why they had brought such incredibly serious charges to the highest court in the land without the necessary documentation to back them up. The atmosphere in the courtroom shifted dramatically from one of righteous crusade set to a grim, desperate exercise in damage control as the massive gap between public relations rhetoric and judicial proof grew wider by the hour, the ultimate, most dramatic turning point of the entire proceeding, centered around a figure who was supposed to be the absolute cornerstone of the claimant's entire case, a private investigator named Gavin Burrows. Originally, the legal team had relied heavily on Burrows as their star witness, pointing to his explosive, detailed statements as the definitive smoking gun that would prove the newspaper publisher had engaged in highly illicit, undercover operations. These initial claims, which the Daily Mail had loudly and repeatedly dismissed as entirely lurid and preposterous, had given the celebrity coalition the confidence to push forward with their multi-million-pound demands. But in a twist that felt more like a sensationalist prime-time television drama than a real-life high court trial, the entire arrangement imploded in spectacular fashion just before the crucial testimony was delivered. Burrows did not merely step back from the spotlight. He actively turned against the very people who had put their trust in him, issuing a stunning subsidiary statement that completely undermined his original evidence. He went as far as to claim that his initial statement was forged, that it was a total fabrication, and that it should not be taken seriously by the court under any circumstances. The shockwaves from this betrayal sent the claimant's strategy into an absolute tailspin, transforming their star witness into a hostile, mocking adversary who seemed to take pleasure in watching their case fall apart. For a layman, the sudden and complete defection of the central pillar of a legal case would seem like an immediate signal to pull the plug, to cut one's losses and retreat before the damage became completely irreversible. Yet, in what many legal commentators have called an act of sheer professional hubris, Prince Harry's lead barrister, David Sherborne, and his team made the incredibly risky decision to press on regardless, marching their clients deeper into the judicial slaughterhouse. The scenes that followed were nothing short of surreal, with Gavin Burrows testifying via a live video link from his solicitor's office, casually dressed in a pair of shorts, openly laughing at the solemn proceedings, and mocking the high-powered barristers as they desperately tried to salvage what was left of their credibility. He did not merely retract his allegations, he actively twisted the knife, publicly declaring the entire litigation to be the single biggest media scam in modern British history. It was a humiliating public dismantling of a high-profile case, played out in front of the national press and a completely stunned judiciary. This unprecedented hostility from their own star witness exposed a deeply troubling aspect of how the case had been constructed in the first place, raising serious, uncomfortable questions about the level of due diligence performed by the celebrity legal team. In any major litigation, especially one involving prominent public figures and tens of millions of pounds, a legal team is expected to perform exhaustive microscopic background checks on their sources to ensure their credibility cannot be shattered under cross-examination. Yet, the cast of characters assembled by the claimants' investigators to support their dramatic allegations seemed to be a walking collection of legal liabilities and red flags. Aside from the highly volatile Gavin Burrows, the investigation team had relied on individuals with highly questionable backgrounds, including a former tabloid journalist who was a convicted phone hacker, and other characters who carried serious, deeply damaging reputational baggage. To the defense and the judge, it appeared that the claimants had built their entire historic campaign on the word of self-confessed liars and compromised operatives who had clear alternative motives of their own. It was a fatal, inexplicable error that completely tainted the integrity of the entire lawsuit, leaving the judge with no choice but to view the entire effort with deep, unwavering skepticism. As the trial reached its grim conclusion, the judgment that came down from the bench was not just a defeat. It was a total, comprehensive annihilation of the claimant's entire legal campaign. The judge dismissed the cases of all 7 claimants across dozens of disputed articles, delivering a scathing, unreserved condemnation of how the litigation had been conducted from start to finish. In a series of biting, legally devastating paragraphs, the judge made it absolutely clear that the claimants had relied almost entirely on broad, unfounded suspicion and creative inference, rather than actual admissible evidence. The condemnation did not stop with the celebrity clients themselves. The judge directed sharp, highly critical remarks toward the professional judgment of the legal teams involved, pointing out serious errors in how witness statements had been prepared and signed off. It was a complete and utter catastrophe for the celebrity coalition, who lost on absolutely every single count they had brought before the court, leaving them facing a monumental, ruinous financial and reputational bill that is only just beginning to make its presence felt. The dream of a historic victory over the British press had transformed, in the space of just a few dramatic weeks, into one of the most comprehensive and humiliating legal self-inflicted wounds in the long history of the English civil courts. With the dust finally settling on the courtroom battle, the focus of this extraordinary legal drama has shifted from the question of liability to a far more cold, calculating, and potentially ruinous arena: the battle over legal costs. In the English legal system, the general rule is that the losing party must pay the winner's costs, but the manner in which those costs are assessed can mean the difference between a painful financial setback and complete financial devastation. Under normal circumstances, costs are assessed on what is known as a standard basis, where the court carefully reviews the bills and only allows expenditures that are deemed entirely reasonable and proportionate. However, because of the exceptionally poor quality of the claimant's evidence, the questionable methods used to secure witness statements, and what the defense argues was overall bad faith in prosecuting the case, the newspaper publisher is pushing for costs to be awarded on an indemnity basis. If the judge grants this request, it will essentially force the celebrity claimants to pay almost the entirety of the newspaper's gargantuan legal bills, with the court resolving any doubts in favor of the winning publisher, with estimates for the total combined legal fees of both sides climbing toward an astronomical £50 million. The impending cost hearings represent a financial cliff edge for the litigants involved, especially given the complex rules governing joint and several liability. Under these rules, because the 7 claimants chose to bundle their individual complaints into a single collective action, the newspaper publisher is legally permitted to target a single wealthy individual, most notably Prince Harry, to recover the entirety of the common costs, leaving him potentially carrying a burden of monumental proportions. This looming financial catastrophe has been made infinitely more complicated by the erratic and highly combative actions of the claimants in the immediate aftermath of the ruling. Rather than accepting the comprehensive defeat with quiet grace and working behind the scenes to minimize the financial fallout, Prince Harry issued a fiercely defiant, highly aggressive public statement that sent shockwaves through the legal establishment. In this public broadside, he did not merely express disappointment. He openly questioned the integrity of the judiciary, describing the ruling as a complete and obvious whitewash and accusing the judge of going to extraordinary lengths to protect the newspaper publisher. To seasoned legal practitioners, this public attack on a sitting High Court judge was seen as an act of absolute madness, especially considering that the very same judge is scheduled to preside over the critical upcoming hearings that will determine the initial costs orders. While judges are highly trained professionals who pride themselves on rising above personal attacks, it is incredibly foolish to publicly accuse the arbitrator of your financial fate of corruption just weeks before they decide whether to hit you with an immediate, multi-million-pound payment on account. The first of these hearings, scheduled for the end of July, is expected to see the newspaper demand an immediate payment of up to £10 million, to be paid within a mere 14 days, carrying a punishing 8% interest rate if the deadline is missed. A demand that would test the liquidity of even the wealthiest members of the coalition. The severe pressure of this impending financial storm has also begun to expose the deep, fragile fractures within the celebrity alliance itself, particularly regarding the less wealthy participants who were drawn into this high-stakes crusade. Among the claimants is Baroness Lawrence, a widely respected public figure from an ordinary background who does not possess the vast global wealth of her co-claimants like Sir Elton John, David Furnish, or Elizabeth Hurley. Reports have emerged suggesting that as the chaotic nature of the evidence became apparent during the trial, Baroness Lawrence became deeply alarmed and expressed an urgent desire to withdraw from the litigation entirely to avoid being dragged into a financial abyss. In a desperate bid to preserve the unity of the coalition and maintain the public relations front, Prince Harry reportedly visited her offices to stiffen her resolve, informally agreeing to personally cover her legal expenses so she would not be left out of pocket by the proceedings. This generous but highly risky promise means that the prince has effectively doubled his own financial exposure, taking on the liabilities of others, at a time when his own insurance coverage is looking increasingly precarious. The high-value indemnity policies taken out by the claimants to protect themselves against adverse costs typically contain strict clauses requiring absolute honesty and transparency, meaning that the insurers may well refuse to pay out a single penny if they can prove that the case was sabotaged by untrue statements, forged signatures, or underhanded witness payments. Behind the scenes of this courtroom disaster lies a dark, fascinating network of evidence gatherers and investigators whose questionable methods ultimately sealed the fate of the entire project. At the center of this network was Graham Johnson, a former tabloid journalist with a prior criminal conviction for phone hacking, who was inexplicably put in charge of compiling the crucial evidence against the Daily Mail. Johnson operated a complex web of contacts, utilizing a project known as Yellow Press to package and publish sensationalist biographies and articles, which the celebrity legal team then attempted to introduce in court as credible, independent evidence of widespread media corruption. The trial revealed that this operation involved paying massive sums of money, in some cases up to £75,000, to individuals in exchange for signing highly explosive witness statements that were prepared by unqualified researchers rather than trained legal professionals. When these individuals were put under pressure, the entire structure collapsed, with key figures like Gavin Burrows publicly revolting and claiming they were offered thousands of pounds a month simply to sign forms they knew to be false. The revelation of these payments has not only destroyed the credibility of the lawsuit, but has also raised the terrifying prospect of severe regulatory action from the Solicitors Regulation Authority and the Bar Standards Board, with several high-profile lawyers now facing the potential end of their professional careers and even criminal investigations for contempt of court or perverting the course of justice. The ultimate significance of this historic legal collapse extends far beyond the personal fortunes of Prince Harry and his celebrity allies, representing a monumental shift in the long-running war over media freedom and privacy regulation in the United Kingdom. For more than a decade, the campaign group Hacked Off has fought tirelessly to impose much tougher state-backed regulations on the British press, viewing this mega-privacy claim as the perfect vehicle to force a second Leveson-style public inquiry through the back door of the civil courts. By attempting to use the High Court to systematically expose what they claimed was ongoing, unchecked criminal behavior within major newspaper groups, they hoped to render the current system of voluntary press regulation completely untenable. Instead, this comprehensive judicial defeat has delivered a devastating blow to the anti-press lobby, marking their first major courtroom loss in 15 years and leaving their regulatory campaign in complete tatters. The judge's refusal to allow the trial to become a public inquiry by proxy has re-established the strict principle that civil courts exist to resolve specific evidenced disputes between parties, not to serve as political battlegrounds for ideological campaigns. Despite the sheer scale of this disaster and the sobering lessons it offers to anyone contemplating high-stakes litigation, it is highly unlikely that we have seen the end of the grand celebrity privacy mega-claim. We live in an increasingly digital, hyper-connected age where the boundaries of personal privacy are constantly being breached. And as long as there are wealthy individuals with massive egos who believe their reputations have been damaged, there will always be high-priced legal teams willing to promise them vindication. The lucrative nature of modern litigation, combined with the psychological inability of many wealthy public figures to accept defeat, ensures that new cases will inevitably rise from the ashes of this historic failure. However, for Prince Harry and his immediate circle,